They have the exact image of what we got from the jail in Fayette County. That is it. And if I get another false allegation and you do nothing, I'm shocked. I'm appalled at you. I sit here day after day with this false allegation just machine. I gave the state everything. There's been no disconstruction. There's been no purposeful, I don't care. I don't care. I give over everything. I've done this for 33 years. Never in my life have I seen a trial. I've done 300 appeals in the state of Georgia alone. I've never read a case like this.
Kenneth Copeland.
Spell it, please.
KENNETHCOPELAND.
Thank you, sir. All right.
And Mr. Copeland, good afternoon. Do you want to be here?
Ma'am,
Do you want to be here?
I'm here.
Okay. Are you going to let me ask you some questions?
Okay.
How old are you?
Grown.
Okay, what does grown mean?
I'm an adult.
Okay. And when you said you're an adult, what number in years are you?
I plead the fifth.
If this honorable court finds that the state knew or had reason to believe that he was going to do this in front of a jury, that his response was going to be, I'm invoking the Fifth Amendment, then, Your Honor, yes, I adopt what you said. That's wrong of the party, and I'm moving for mistrial.
Okay.
Okay.
All right, sir. Thank you. I'm going to deny the motion for mistrial, Mr. Steele, at this point in time. I'll note that you've made it.
Thank you.
Go ahead.
The way I understand my constitutional obligations, pursuant to the 6th and 14th Amendments of the United States Constitution, the corresponding sections of the Georgia Constitution, I'm required to make a full and complete statement to the court. For the record, and if God forbid this goes up on appeal for the appellate courts or another tribunal, commission, or administrative body, I was told, based upon information and belief, that when we arrived at 8:30, 9 o'clock today, he did not come into your courtroom until almost 11:30. And what I found out just recently, this is not waived, is that supposedly in chamber, court reporter at times, court at times, district attorney or district attorneys from the DA's office, as well as investigators, sheriff deputies, Mr. Copeland and his counsel met together. None of the defense team, to my knowledge, was aware that this was going on. It was told, based upon information belief, that it was told to the district attorneys that Mr. Copeland intended to plead the Fifth Amendment. Then I was told, based upon information belief, that Adrian Love, the lawyer for Mr. Copeland, and this court were together, and Ms. Love made representations that John Melnick supposedly spoke with some attorneys for the accused and wrote an email to Ms. Love, to Adrian Love, stating that Mr. Melnick does not represent the witness, and that Mr. Melnick wrote an email saying F you, and then somehow that email was CC'd to me. That never...
Mr. Steele, can I interrupt you for just a second? I'm kind of disturbed because that's ex parte.
What I want to know is, why wasn't I there? Why,
Sir, I'm going to hold you in contempt if you don't tell me who this. Tell me who this information
I don't
was
want to
coming
be
from.
held in contempt.
Well,
I'm not
then
answering that question. That's attorney-client privilege information. I am not answering.
Attorney-client privilege. Unless you were in my chambers, that's the only way you can figure out.
I am
I
telling
tell you
you-
what, I'm going to give you 5 minutes. If you don't tell me,
You don't
who
have
it
to.
is-
I'm
if
gonna
you don't tell me who it is, I'm going to put you.
But let me-
I'm going to put you in contempt
I
because
understand.
that is not attorney-client privilege.
Attorney work product privilege. I am not.
How did you get that information supposedly
answer
from
that
my chambers? Did somebody tell you?
I'm not. You should have told me. You got 5 minutes. Well, I don't need it. I want to continue.
You got 5 minutes?
This is what I was told. Mr. Copeland made statements that he admitted to killing Donovan Thomas and was, don't take my notes. No. But you're acting like, tell me who it is and don't talk about the substance. Why can't we have an issue that was outside of presence? It should not have been.
Because you got some information that you shouldn't have gotten.
Why?
Well, we can, that's for another day.
But why?
Okay,
Why
that's for
did we
another
exclude
day.
in the first place? I didn't know about this stuff.
That's
I raised
for
it
another
before
day.
the
So
court. I raised it as soon as we found out about it.
Well,
I gave you the case I'm relying on. I assume you read it. If you didn't read it, you should read it. It's a material part, a critical part of the case. When a judge speaks with a witness outside the presence of the accused, the court has said it's right there in Division 2.
okay.
That is a material or critical part of the case, and it's an automatic reversal.
Mr. Steele. This court has decided to release the entirety of the transcript of those proceedings as courts won. And I'm going to take judicial notice of the following timeline. On Friday, June the 7th, 2024, Mr. Kenneth Copeland was granted immunity from prosecution pursuant to 24-5-507A, and that will be marked as Courts 2. So the transcript will be Court 1. His immunity agreement, Mr. Copeland's, will be Court 2. Mr. Copeland, who was represented by Mr. Jonathan Melnick and advised of his rights and obligations, during the proceedings on Friday, June the 7th, which will be marked as Courts 3, the transcript of those proceedings, Mr. Copeland invoked his Fifth Amendment privilege and was held in contempt, and that will be Courts 4, Mr. Copeland's order of contempt. Mr. Melnick informed the court that he was not going to be in attendance of any further proceedings as he would be on leave effective 10 June of 2024. The court informed Mr. Melnick that his leave, or I had discussions with him that his leave was not proper and that he needed to be in attendance on Monday, June the 10th of 2024 with Mr. Copeland. Mr. Melnick relayed that attorney Caleb Bumpus would be representing Mr. Copeland. On Monday, June the 10th, before court, Mr. Edward Chamberlain, the court's litigation manager, informed the court that the state wished to have an ex parte meeting with the court. No subject matter of the ex parte meeting was told. The entirety of the ex parte hearing held on the 10th of June of 2024 was taken down by Miss Christina Weaver, the court's official court reporter. This ex parte hearing was held in chambers starting at 9:10 a.m. Present along with the court were Miss Caleb Bumpus, attorney or ADA Miss Adrian Love. Also present were the DA's investigators, Mr. Long and Mr. Hamilton. The ex parte hearing stood in recess from 4 to 10:03 a.m. to await Mr. Copeland's arrival. The ex parte hearing resumed with Mr. Copeland present at 10:03 a.m. Also were attorney Bumpus, Ms. Hilton, the DA's investigators Long and Hamilton, with the court and security personnel, deputies Houston, McPherson, Brown, Sergeant Brown, and Sergeant Hall. The ex parte hearing stood in recess to allow Mr. Copeland to have a private conversation with attorney Bumpus from 10:17 a.m. to 11:28 a.m. The ex parte hearing resumed at 11:28 a.m. The ex parte hearing concluded at 11:31 a.m. The court arrived in courtroom 1C at 11:49. That will end the transcript of those proceedings starting as of 11:49, or when the court held the proceedings on 10 June in courtroom 1C 2024. That will be marked as Courts 5. The proceeding in 1C commenced on the record at 11:52 a.m. A lunch recess was had at 12:51 p.m. The parties returned from lunch, and Mr. Steele informed the court that he had a motion, and that was at 1:46 p.m. In asking then Mr. Steele later that afternoon was held in contempt. However, he was allowed to continue representation of Mr. Williams. The court, in asking Mr. Steele questions of how he received the information that he proffered in open court, was only concerned about the integrity and security of the conversations that were had in chambers, not whether those conversations were the subject of proper ex parte conversations or the sum and substance of what was told him at that time. Jurors Jurors entered the courtroom to resume Mr. Copeland's testimony at 3:39 p.m. The jurors were excused and exited the courtroom at 5:56 p.m. Mr. Copeland was excused and exited the courtroom at 5:58 p.m. The court asked Mr. Steele again whether he received ex parte information, and that would be at 5:59 p.m. Mr. Steele's counsel, Ms. Ashley Merchant, and Mr. Alex Susor entered the courtroom. Mr. Steele was held in criminal contempt. That order of that contempt will be marked as Court 6, and the proceedings concluded at 7:41 p.m. The court further takes judicial notice of the following statements proffered by Attorney Steele, Brian Steele, in open court upon information and belief stated to the court, which are still unknown. There are 6 assertions that Mr. Steele proffered in front of the court. Those are contained within the transcript of Courts 5, the proceedings that are held on the 10th of June of 2024 in courtroom 1C, which the court's already said will be part of this order. The first assertion and the transcript bears out exactly what Mr. Steele said, so the court is paraphrasing the 6 assertions that Mr. Steele made. They're more aptly and more eloquently put in the record. The first one involves his concern that supposedly in chambers, this honorable court reporter, court at times, district attorney or district attorneys before the DA's office, as well as investigators, sheriff, and deputies, Mr. Copeland and his counsel met together. None of the defense team, to his knowledge, were present. Second assertion he makes is that Mr. Copeland intended to plead the Fifth Amendment. Third assertion is that Mr. Copeland, as a party, was sworn, and Mr. Steele asserted that this particular conversation was, in fact, a critical stage, and that the defendants had the right to be present. The fifth group of assertions involved Mr. Copeland not going to testify. The fifth group of assertions involved what Ms. Attorney Hilton claimed or said to the witness, to include the court, involving allegations of coercion and witness intimidation, and that his counsel had the right to be present. And the sixth assertion that was made in open court was that Mr. Copeland admitted to killing Donovan Thomas. At some point after Mr. Steele was held in contempt by this court in the afternoon of June the 10th, it was brought to the court's attention, not at the court's request, by security personnel, that video footage of what occurred outside courtroom 1C shows the interactions between Ms. Bumpus, Mr. Steele, Mr. Adams, and Mr. Sharp. The court in no way sought to investigate any facts of this footage, and it only considered it for the security and timeline of events that occurred on June the 10th of 2024. Also, in no way did the court consider any of this footage in holding Mr. Steele in contempt. And as I said, mentioned it only for the purposes of considering the security and breach of information within the court's chambers, not for whether or not that was truthful or not. Mr. Steele makes further made three assertions on the 10th of June of 2024. One, he asserted that this was, on behalf of Mr. Williams and similar situated individuals, that this was, the court held an improper ex parte meeting. Secondly, that Mr. Copeland was a sworn witness and Mr. Copeland was a sworn witness, and third, that he argued that this was a critical stage and that he and the others needed to be present at that point in time to pursue the Sixth Amendment rights of in this case. As to Mr. Steele's first assertion of whether or not the court held an improper ex parte, the court is guided by Judicial Code of Conduct 2.9, which I'll take judicial notice of, which the court further takes no position on whether Mr. Steele, his use of the June 10th proffered information, as his use on behalf of Mr. Williams, are guidelines as set forth in the Georgia Rules of Professional Conduct. The court's basis for having been explained on the record, a written order of this, along with the attachments, will be included in the record. And Mr. Banks, where are you? Sir. As a result of this transcript release, the court withdraws the show cause for others who may be present who are present in chambers on the 10th of June of 2024. And as I mentioned earlier, we were going to have a show cause hearing on Wednesday, the 3rd of July. I am canceling that indefinitely. In fact, I've canceled all of that, so we will not be holding that particular hearing, okay? All right. And then as a matter the court wanted to put on record, upon further review, this court will in fact enter an order sending Mr. Adams and Steele's, Mr. Weinstein, and Mr. Banks' motion to recuse to another judge pursuant to Uniform Superior Court Rules 25.1 through 25.7 in the method and manner prescribed by our local rules. So, when order is entered, I will enter the order transferring it, and until such time as those two things are decided, then we'll be in recess until that time.
Okay, we're going to go over the YSL ex parte documents. The judge released them yesterday at 7:45 p.m. And this is going back to June the 10th, 2024. Let me go back up here. I want to see something. Okay, so here we are. The ex parte hearing began at 9:10 a.m. Present in chambers, which was Judge Glenville, Assistant District Attorney Adrian Love, Attorney Kayla Bumpus, Court Reporter Christina Weaver, and investigators Antonia Long and Rashid Hamilton. And then it says the court reporter, okay, I'm ready whenever you are. Now, let's get into this. We'll move it up a little bit so we can read it. And I went over this already, so I try to go over everything before I present it to you. So, Miss Love, thank you. The concerns that we wanted to bring to the court's attention as the state was twofold. One, we wanted to have the opportunity to impress upon Mr. Copeland with representation present that he faces, and we wanted to give him an opportunity to ask whatever questions for he was sort of, and then it got some spaces, I guess she paused. We had to pull him in the courtroom when the jury came out. The second concern that I have is, and I wanted to bring to the court's attention in line with the concerns that I expressed on the record on Friday. I don't know what advice counsels may have offered or may be offering. That is their right and their business. As it relates to testifying, however, I do not believe that criminal exposure is a concern. Okay, that's very important. As it relates to testifying, however, I do not believe that criminal exposure is a concern. That is which interest is being spoken about and protected. Mr. Melnick relayed to Mrs. Hilton on Friday that he had never heard of a statute 24-5-507. And on Friday, let's go down to page 4, he sent an email. I don't know if he intentionally copied Mr. Steele and Mr. Schroedick. I'm not sure if I'm saying his name right, but that's the other lawyer. I don't know if he unintentionally put my name on it, but he sent an email to Mr. Steele with me and Simone copied where he said, now remember, this is Little Woody's lawyer. This is the communication that I received from Mrs. Love regarding Mr. Copeland. My response was, whose interests are you protecting? Yours or Mr. Steele's? Whose clients? Which client are you protecting? Whose clients? Yours or Mr. Steele's? He wrote back and said, you are going to get him killed. You have made him, then it's a little pause, you're making him a target. F you. Ooh, these lawyers, boy, he told her to F herself. Is what he wrote in the email. Ew, so we see why Woody picked that attorney. Okay, so let's keep going. Okay, we're on line 13. So given that his concerns is that by testifying, at least the one that he conveyed to me in writing is not, then she pauses, his concern has nothing to do with exposure from the state. And if his concerns, then she paused. Now, when it says the court, that's the judge. That's Glanville. He's being whose concern? Then Miss Love, Mr. Melnick. If the interest that he is protecting is Mr. Copeland's freedom, he did not convey it by asking us what exposure does he face in testifying. In fact, if he's concerned that testifying will get Mr. Copeland killed and he's not communicating with us, he's communicating with counsel for defendants. It would, let's go down, it would seem that he knows a thing or something that we don't know. Additionally, and I will let Mrs. Bumpus tell you. Okay, let's go on down to this next page here. He has said, if Mr. Copeland testifies, he's no longer representing Mr. Copeland. which is strange because if you're interested in your client, then it would seem you would want to be there for him while he is testifying. And here goes the judge. Well, he is on vacation this week. Then here's Mrs. Love. I understand that is why he has Mrs. Bumpus here. And he has said what he has said. Oh, suck it. And as I was reading the statute, the thing that is, then she pauses, and I was reading the statute about his particular situation. And I was reading our rules, our ethic rules, rules of conduct for attorneys. And it is clear that if an attorney, then she pauses, there were two things that were happening. One, Mr. Melnick had told me that he wasn't Mr. Copeland's lawyer. Mr. Copeland had told Mrs. Hilton that Mrs. Melnick wasn't representing him. And then rather than Mr. Copeland reaching out to Mr. Melnick apparently was in communication with Mr. Steele and Mr. Skardick. I don't know if I'm saying his name right, y'all. I'm sorry about that. And Mr. Melnick reaches out to Mr. Copeland and rejects himself in their proceedings. Let's move this down so I can make sure y'all see it. We're on line 20. What we were discussing was in no way a matter that Mr. Melnick was representing Mr. Copeland on, and that is where we are not allowed to speak with a person when they are represented by counsel. Mr. Melnick could not have been representing Mr. Copeland on anything we were talking about because we were talking about this case and this trial. All that aside, we would like an opportunity for the court to address Mr. Copeland. With Mr. Copeland's stand-in counsel present, Mrs. Bumpus is looking at me like, okay, number 5, this is Mrs. Bumpus talking, which is Woody's attorney. And she says, I'm listening. Then Mrs. Love, let me move it up, y'all. I moved it up too much. I want y'all to be able to see everything like I see. I'm on line 6. Mrs. Love, with his standing counsel president to allow Mrs. Bumpus an opportunity to explain to Mr. Copeland everything that I have just said. Her concerns outside was what is the longest he can stay in jail. What I relayed to her is the statute says until he purges. Then here's the judge. By testifying, then Mrs. Love. His contempt by testifying. The judge, 507 is a little bit different. So and then Mrs. Bumpus speaks. So until the end of this, then the judge. He can be here until the end of the trial. Then Woody's lawyer. That is what I said. To the end of the trial is the longest. Then Mrs. Love. No, it's not the longest. Even at the grand jury, if a person has been subpoenaed to testify before the grand jury, and even after the grand jury has what it is, let me read that again. And even after the grand jury has what is it convened, has left, that person can stay in until the person purges himself of contempt by, sound like she wrong already right here, y'all, but let me see what she say. By testifying, the statute literally says that she's wrong, you guys. She's wrong right there. After the trial ends, they supposed to let him go because he can't testify no more. What are he gonna testify to? The trial ended. So she's wrong on that. Okay, let's move it up. We're gonna go to line 2. Woody's lawyer says, well, I'm going to look it up because it was my understanding that it was until the end of trial. Exactly. Come on. That's right. Mrs. Love, no. Here it is. Literally the words of the statute. And so then here's the judge. He could be there a while. Let's put it that way. Either way. Then Woody's lawyer. I just want to be able to give him. Then she pauses. Then the judge says, I know. It's kind of the statute says, that you're purged, but I can't keep him in there indefinitely. I've got to then he pauses. Then Woody's lawyer says, right, that is all I want to know. Then the judge says, The whole thing is that he pauses, he has the keys to his own freedom, and that freedom is if he just gives his testimony, then he's purged it. Then Woody's lawyer, right. Then Mrs. Love. And you know, whatever that testimony is, we know what we believe it to be, but you know, we don't know what it is. We can't talk about it. We don't. You know, I mean, we don't know what he's going to say. We have an idea. We know what he told us. Then Woody's lawyer, she says, yeah, let's move it up. We're on line 23. Mrs. Love. And our concerns is that if then she pauses. Our concerns, then she pauses. I know the court said essentially you intimidated that you pauses that Mr. Melnick probably told him essentially you should testify. They're not going to, then she pauses. They can't do anything with your testimony. But what we've overheard being said was they're going to hammer you. As if we were going to expose Kenneth Copeland too. Then she pauses. Then Woody's lawyer says, you heard that? Then Miss Love says, yes, yeah. Mr. Melnick told Mr. Copeland we're going to hammer him. Let's move it up. Okay, we're on number 9. Then that's the judge. Now, to be fair, and I think Mrs. Bumpus as an advocate or anybody has got to tell him he's going to face some pretty significant cross-examinations. And I think that's what he meant when he said hammer you. Then here goes Woody's lawyer. Yeah, I think that's what he meant. Yep, she agreed. Okay, then here's the judge. I mean, he's got about 10. Then here's Mrs. Love. So he meant the defense is going to hammer him. Then Woody's lawyer, no, just in general, it's not going to be a, hey, da. Okay. Then Mrs. Love, he knew that. He had already been expressing that. Then here's the judge. But, I mean, I think that if he's concerned about that, well, you know, but then he pauses. It's all in the message and the packaging in terms of what I think. Mr. Copeland is, you know, a savvy person. But, you know, he's certainly going to be subject to a thorough and, let's move it up, sifting cross-examination. Then Mrs. Love. And the other thing is that, then she pauses, Woody's lawyer. Can I just say something in attorney defense in response just for the record? Mrs. Love, yes. Woody's lawyer, the reason that he doesn't want to move forward with representation, I've been told if he decides to testify, is that he doesn't feel like he can. Then she pauses. He doesn't know what was said outside of his presence. So he doesn't feel like he can adequately represent him or counsel him because he doesn't know what was told to the state when he wasn't there. Which is a problem because they shouldn't have been talking to him without his lawyer present. But let's continue. Ms. Love. But the thing is that the only thing that he should be concerned about is the criminal exposure or the exposure that Kenneth Copeland has criminally. And there is nothing. There is literally nothing. The statute is quite clear that we can do to him about, and she pauses, the only thing that we put him in harm's way is a lie and a refusal to testify after being ordered to do so by the court. And by a lie, we don't mean like, oh, I think you're lying. You know, it would have to be, you know, something obviously, you know, because we can always impeach. But if, let's move it down. He literally purges himself. That's something different. We can't help that. We can't control that. We would only say, tell the truth. I don't care how bad it is, just tell the truth. So, you know, like he says, I didn't go down to the police station. Then the judge starts speaking. And I think part of his challenge, Mrs. Bumpus, may be that you need to assure him, look, I'm going to be here. And if you think that they are asking you a question, They being the state or the defense is asking you a question that's going to bring out other crimes that you are going to, then he pauses. He's going to be able to look to you and say, can I have a chance to talk with you? Okay, let's move it up. We're on line 13. Mrs. Love, that's exactly right. Mrs. Bumpus, Mrs. Love, see, but that's just it. Mrs. Bumpus, no, he's not. Mrs. Love, hold on. That's just it, Judge. The problem is that there's been an assertion that people are representing, and I'm not talking about you. And then Ms. Bumpus, Woody's already said, yeah. Mrs. Love, there's been assertions that people are representing his, and then she pauses, that their biggest concern is his best interest, and then they are just not here. And Mrs. Bumpus is saying she's not in position to do that. Okay, let's move it up. We're on number 1. Then Woody's lawyer says, no, I'm not saying I'm not in a position. I'm saying that the agreement between Mr. Copeland and Melnick, who I'm standing in for, is that if he chooses to testify, I'm to get him to sign this paper that says that then discharge Melnick as his rep. Then she pauses. That's their agreement. I can't do nothing about that. Then Mrs. Love, that sounds weird. That does not sound like something in Mr. Copeland's best interest. That sounds like protecting somebody else's best interest. If you talk, I can't. Then she pauses. I ain't going to. Then she pauses. I'm not going to represent you. I don't even know what to do with that. Woody's lawyer, well, he said he does not know what was said. Then Mrs. Love, it doesn't matter what was said. Woody's lawyer, right. Mrs. Love, it doesn't matter, and he didn't ask us. He didn't even inquire. What have you all talked about? Let me see. Yeah, what have you all talked about? He has been talking to Brian Steele and Max. That's it. He is not talking to us. Okay, she said he hasn't been talking to them. Okay, remember that, y'all. And in fact, when Mr. Copeland asked to speak with us, Mr. Melnick barged in and gets between Mrs. Hilton and Mr. Copeland and literally, keeps us from talking to him before he gets called to the stand, and that's troubling. Okay, that was line 23. Then Woody's lawyer, well, I think what happened was, then she paused, and I say this because I previously represented Mr. Copeland previously on his other stuff, so I know when she pauses, this is just what I think happened. I think how Attorney Melnick came involved was his representation of others, because he took my place. Copeland fired me and hired Melnick, and then this came about. And I think so at the beginning, Melnick was representing him, and then she paused, Mrs. Love, in his criminal matter that he had, but that's resolved. Woody's lawyer, but when this case started, Melnick called me and told me that he was representing him as a witness at the beginning. I can assert that. Let's move it up. We're on line 13. Mrs. Love, Melnick has never in his life. Woody's lawyer, this is 2 years ago. Mrs. Love, Melnick didn't, then she stopped. As a matter of fact, less than 2 years ago, when Copeland was sitting in jail from something else he had done, Melnick said, I don't represent him. He told me I didn't represent him, and people were in the room. He was on speaker. He told me he didn't represent him. Now he ultimately did come and represent him. But when we were trying to get, I guess, then Woody's lawyer, something, yeah. Mrs. Love, Copeland was like, he's not my lawyer. I don't have a lawyer. He's not my lawyer. And then, well, line 2. Woody's lawyer, are you talking about recently? Mrs. Love, so recently Copeland said that Melnick was not his lawyer. Woody's lawyer, right. Mrs. Love, when Copeland was in jail, Melnick told me he wasn't his lawyer, but our understanding was that Melnick was his lawyer for those criminal charges. And so the person that came in and argued, or at least stood in for him on his bond and then on his plea, was Melnick. But I don't know who interest he would be representing when he's not talking to us about what we've spoken to Copeland about. See, she said they hadn't talked to him, but right here, they done spoken with him. Okay, let's keep going, y'all. He could ask us and we would tell him, so I don't know why he would withdraw his representation of him if his interest is Kenneth Copeland. Then why would you pull out? The judge: that doesn't make sense. Mrs. Love: at the point where he would face the most peril of that is his concern. If his concern is, I don't know what they're talking about, so I don't know what. Then she pauses. The judge: and I thought that Mrs. Hilton had a letter to Copeland anyway. Mrs. Love: she did. Let's move it down on line 25. The judge, sorry. Well, how come you all can't? And he pauses. Let's move it up. Mrs. Love: he didn't ask to see those. He didn't, and not only that. The judge: well, can't you all share that with Mrs. Bumpus? Mrs. Love: well, Miss Hilton has already shared it with Mr. Copeland. Thought they wasn't talking to the guy. And we certainly would share it, generally speaking. Then Woody's lawyer: can I read this email that Melnick sent me? I don't know if this will help you understand what he's saying. It says, hey Kayla, I wasn't able to see Kenneth today. He went in on Saturday. Let me reread that, y'all. Let me go back up to 8. Woody's lawyer: can I read this email that Melnick sent me? Oh, she wants to read the email. Sorry about that. I said it a little wrong. Okay, let's keep going. I don't know if this will help you understand what he's saying. It says, hey Kayla, I wasn't able to see Kenneth today. He went on Saturday and I tried talking to him before his flight, but I have talked to his family. So at first Kenneth was going to testify, but has now decided to take the 5th. He may change his mind on Monday. If he does, then he's agreed to discharge me as his attorney. This isn't out of bad feelings, but I was not present when he met with the DA's office, so I can't really help him with his testimony. And then he gave me the discharge and told me that if he decides to testify, then he's to sign this. So she's letting him know her conversation between Melnick. Okay, let's move it up. Line 23. Mrs. Love: and that's just it. It's like you never know what somebody's going to ask, and if he's concerned about putting him in legal jeopardy, then she pauses, it would seem like he would remain and allow Mr. Copeland access to counsel when Mr. Copeland is concerned that he's about to walk into an area that puts him in legal jeopardy. Let's move it up here, you guys. Then Woody's lawyer: you can't switch how he gets called. Mrs. Love: see, that's not in Mr. Copeland's best interest. That's in the defendant's best interest. When you say switch in how he gets called, what does that have to do with anything? Woody's lawyer: I don't know. Maybe he's saying he can't do it because he can't get his refundable ticket. Mrs. Love: that is not what he said in that email to you, and that is not what he relayed to the court, and his concerns have nothing to do with it. The judge: he was very much. Woody's lawyer: I tried to go back and watch as much as I could. The judge: telling me that he was going on vacation. The judge told him. He did tell him, and he told him way back in December. And I said, well, you're inserting yourself in this. I said, really, you need to come on Monday. This is stuff. So he can't force Mr. Copeland to discharge him just because Mr. Copeland decides to testify. The judge: I think you're in until it's done. I mean, And then Woody's lawyer, Miss Bumpus: who, me? The one he fired. The judge, yeah, I mean, that's just, if he testifies, you've got to kind of, then Mrs. Love, frankly, Your Honor, I know that if a person faces criminal contempt, they are entitled to representation if they want it, then this being a civil contempt matter. The judge, not necessarily. Anybody who's facing contempt can get counsel. I mean, you know, not anybody, but then Woody's lawyer, I can't stay. How long is this going to take? Mrs. Love, it might take some days. Woody's lawyer, Then Mrs. Love, and see, that's just it. And I don't mean, I think Mrs. Bumpus is put in a precarious position. She's not the one that stood up and injected herself into this. They reached out to her and she did him a favor. But ultimately, it seems as if Mr. Melnick is stalling and attempting to delay and hamper and hinder our proceedings. And that is a problem because that has nothing to do with the best interests of Kenneth Copeland, and that has nothing to do with Kenneth Copeland's exposure if he testifies. Okay. 24, just to answer the question about what he is exposing to, the statute is very, very clear. It's literally saying, let's move up to 1, that no testimony or any evidence required under the court's order or any information directly or indirectly derived from such testimony or evidence shall be used against the person in any proceeding or prosecution for a crime or offense concerning which he testified or produces evidence under the court order. That is saying, even if he got on the stand and said, then here goes the judge. He started talking about an unrelated crime, which is what the biggest thing I think he's probably thinking about is that, yeah, that there's a lot of stuff they could ask me about. Mrs. Love, right. Then here's the judge. That is not knowing to a lot of people, and that, and he pauses, you know, he could also invoke his Fifth Amendment with the advice of counsel if it was some other particular crime. But, then here goes Mrs. Love, but even that, we wouldn't even, the judge, even that he'll still have to testify. Then Mrs. Love, literally, right, they say, I think she's supposed to say, the law says, I think that's just the word, the S should be with an L, the law says. Then the judge says, yeah, I mean, anything he testify. Mrs. Love, we do this. Then Woody's lawyer, okay, and then about the delay or stall, isn't it true or is it not true that he had a leave? She said she on him. Filed since December. Exactly. Mrs. Love, we had nothing to do with any of that. He injected himself into this. The judge, yes, see, the problem is, then Mrs. Love, he stepped in. And then the judge, that's when you get involved. I don't know, you have a leave. Then Mrs. Love, right, you, and then the judge, unless you file that leave into this case, you don't have a leave for my case. Mrs. Love, right. Mrs. Bumpus, okay. Then Mrs. Love, and he did not. And the judge says, so he didn't have one? Mrs. Love, Mr. Copeland's been a witness and a name on this witness list since, and then she stalls. So since he said, well, I represent him, I'm like, okay, well, you don't have a leave that's filed in our case. Then Woody's lawyer, okay. Then Mrs. Love, so he did this to himself and he did it to you, but we have to, you know, that is just where it is, and I don't know that. That's just where we are. Let me move this up. Then Woody's lawyer, so Judge, you are going to make me stay if he chooses to testify? Let's move it on up to 1. Then the judge says, I am, because you're his lawyer. You're a stand-in lawyer at this point. Then Woody's lawyer, Your Honor, I don't have a problem with that. I'm not ready. This Mrs. Love, then the judge, there's nothing for you to be ready about. I mean, here's the thing. I think the only thing you've got to kind of ask him about is, look, here is the question. The state is going to ask you, all right? Is there anything else that could hurt you that they might ask you about? And as long as you have acknowledged of that, then I think that you are fine, because the state's only going to get into this. Now, the reason you want to know what's going to hurt you is the defendant knows more about Kenneth Copeland than anybody else. So they're probably going to kind of, then Woody's lawyer, what about if I say I can't do it? Then Melnick needs to come back, right? Am I going to be in trouble? Because I was only for Monday. That's what I was told. I was given specifics. Then Mrs. Love, if Copeland said, then she pauses, I don't know what Mr. Copeland wants. It's his choice. Then Woody's lawyer, can he say he doesn't want Melnick? Mrs. Love, he can say whatever he wants. It's his choice. Then Woody's lawyer, but the judge is saying, then here's Mrs. Love, I don't think he can be forced to have representation if he doesn't want, need, or say he wants it, because we have done everything to clear him of exposure. He's not there. There's nothing he could say. He could lie. That puts him in, you know. Then the judge, peril. Mrs. Peril, but you know, he could talk about a crime that we could then prosecute him for. Then the judge, that is involving this or some other place. Mrs. Love, right. Woody's lawyer, I understand that, but Mrs. Love, and we can't use his testimony to go find evidence to prosecute him for the stuff he talks about. Basically, he is literally shielded. Woody's lawyer, I would have to agree with you that I don't think that that's his concern. Isn't that what you said? Well, the court said that. Woody's lawyer, no, I'm saying with Mr. Copeland not testifying, you said you don't think that his concern is criminal. Excuse me, you guys. Criminal exposure. Or do you think that it is what he's worried about? Move it down. The court, which is the judge, do you think that he's fearful of testifying for other reasons, like for his personal safety? Woody's lawyer, right. That is what Mr. Melnick said to me in an email I could pull up. He said, Woody's lawyer, but you don't, I'm thinking as I'm reading y'all. Woody's lawyer, but you don't believe that. Mrs. Love, you're going to get him killed. That's what he said. We ain't going to kill him. And then Mrs. Bumpus, Woody's lawyer. See, I don't know anything about that email. Mrs. Love, we ain't going to kill him. I can show you the email, but we're not going to kill Kenneth Copeland. So who is he talking about? So what are you trying to do? The judge, that is a collateral second and third order effect. You know, like, let's pray it doesn't happen, but... And then Mrs. Love, I mean, obviously then let's move it up, because the judge got a lot to say here so we can see it all. The judge, first he has to give testimony though. I mean, that's what he has to do. He's got to give the testimony, whatever it is, good, bad, or indifferent, I should say. Mrs. Love, so we would like, with the court's permission, they haven't brought him over, and he was supposed to be the first one up. So I guess they went to go to get him. They might be over here with him now. The judge, is he here now? Mrs. Love, I don't know. Let's move it up. This is when it's finna get, yeah. And then Judge Glanville exit chambers at 9:30 a.m. Then Mrs. Love says, we would like to just go into another courtroom and talk to him. Give you a chance to talk to him, and then give you an opportunity to explain to him. Then the court reporter says, we're off the record. Brief recess. Then Judge Glanville and Mr. Chamberlain enters chambers at 9:34 a.m. So he was only gone a minute. Then Mrs. Love, Mrs. Hilton has been communicating with him. I thought they wasn't talking to the man. I like to grab her from downstairs and have her come up. Oh, she's been down there talking to him, you guys. The judge, where is Mr. Copeland? Mr. Chambers, they took him upstairs to the tank in 9. The judge, okay, can we bring him out to, can we? And then Mr. Chamberlain, your chambers is being used. Your courtroom is being used. Then the judge, let's bring him in here. Mr. Chambers, all right, so let me see if I can get that done. Let me move this up because this is where it's going to be something. Okay, 24. The judge, let's bring him in here. Okay, thank you. We'll just bring him in here. The proceedings stood in recess from 9:34 a.m. to 10:03 a.m. So that was like 30 minutes, 20 minutes. Yeah, about 30 minutes. Okay, number 3. Mr. Copeland entered chambers at 10:03 a.m. Also present was Judge Glanville, Assistant District Attorney Simone Hilton, and Attorney Kayla Bumpus, Court Reporter Christina Weaver, Investigator Antonio Long, and Rashid Hamilton, and Deputy Houston, Deputy McPherson, I don't know his name, y'all. Sergeant Brown and Sergeant Hall with the Fulton County Sheriff's Department. I think was that Mike Firestone? Okay, but let's keep going. Let's move this up here. Okay, the judge. Okay, Mr. Copeland. This is Woody. Can you let him know I got a hearing problem? And then Woody's lawyer. Okay, he said can, and he is hard of hearing. The judge. That makes 2 of us. I've got a hearing aid that's coming on the 27th of January. Of June. So I'll try and talk loud. Is it okay if I? Woody. Yeah, I can read lips. The judge. Okay, good, Mr. Copeland. Good morning. Woody. Good morning. The judge. All right. I just want to bring you over and let you talk with Mrs. Bumpus and see if there is anything that you need to ask of your counsel or Mrs. Hilton or the state or the court before we bring you out let's move it up, y'all, this morning, because we would like to hear your testimony, and that is kind of where we are at this point in time. So is there anything you want to ask? Woody, well, I want to speak to you personally that I have never been truthful a day in my life until I just made this. I don't comprehend none of this stuff that's going on. The judge. Okay, well, the only thing you can give is truthful testimony. Whatever you know is whatever you know. That's it. Mrs. Hilton. And what we'll say, and Mr. Copeland and I, we have talked about this. See, she's been talking to him, you guys. I'm not sure what your concerns are, what concerns that you expressed to Mr. Melnick last week. But if any of your concerns deal with being locked up for anything, you can't, there's nothing that can happen. The feds, and then Woody's lawyer, well, that's not, and then Mrs. Hilton interrupts. It is true. Woody's lawyer, no, I said that's not his concerns. Mrs. Hilton, if his concerns are safety, we need to know that. That's not expressed, so we don't know. Let's move it up. 23. What's the concerns is so that we can try to resolve the concerns. This is what I'm saying. Mr. Copeland and I have had, let's move it up, conversations before. I understand some of his concerns is potentially criminal liability, hence why we gave you immunity. The federal statute of limitations done, the state statute of limitations done. So there is nothing, I researched it this weekend again, both those statutes of limitations for what you and I talk about, which is in 2015 or before. Done. You cannot be prosecuted for anything you testify federally or statewide. Immunity, period. Pay attention, y'all. So if that is the concern, there is none, because you cannot be prosecuted. The federal statute of limitation is 5 years. So anything in 2015, 5 years would have been in 2020. Anything statewide is 4 years. It would have been 2019. Finished. Next concern. What may happen in the streets, what we have talked about, what we can do as far as living and all of that. We have had those conversations. So I'm trying to express to you, excuse me, you guys. It's a lot of reading. Let me see, where was I? Express to you, where was I? We do not want you sitting in decob, or whenever they got you because of this. Let me move it down. I know you wanted to talk to me on Friday before you walked into court. We weren't able to talk. If you still want to talk with or without Mrs. Bumpus, I'm here, but we do not want you in custody. Number 2, you will not. This order, I don't know if you kept your copy of the order, but this order says you are immune from prosecution, any of it. Literally, Judge, you might want to close your ears if you confess to a murder on the stand. If we don't have any other independent evidence outside of what you say on the stand, you are immune from prosecution from what you say in court. That right there. Okay, you guys, this boy, I don't blame, he needs to plead the fifth, because what they're saying is they can't use his testimony against him, but they can get evidence to what he said and prosecute him. So say for instance, he testified, he unalived somebody. They can't use that in court, but they can go and get evidence of him doing it, and they can prosecute him still. He can immunity. That, yeah. Okay, let's keep going. Line 9. So again, I don't know what was communicated to you on Friday. I have no idea. But what the state has assured you, which I've assured you in our private conversations. See, she been talking to this man. With Mr. Long, as I'm saying in front of Mrs. Bumpus, as I told you that it was this, or this is what this order says. Here goes the judge. And that is direct or cross-examination. Mrs. Hilton, and that is direct or cross-examination. Here goes the judge. So if you are worried about what the defendant may ask you, because they may know your business, but if they ask you about things that you might think you might have some liability with, you can't be prosecuted for any of those. Here go Woody. I got family members watching this trial, and I don't want my nephew and them to hear the things that I may be involved in and think it's okay. Okay, let's move it in. We're at 24. Mrs. Hilton, but I think that's a separate conversation you can have with them as an honest, let's keep going up. Number 1, individual, like, look, nephews, I don't live in this life that I don't want you to live. Don't go through what I've been through. But that's something you can have outside of being in jail, because that's a better conversation you can have with your nephews in person. But they shouldn't have to come to the DeKalb County Jail because you are being held in contempt. You can have that conversation with your nephews tomorrow in person. You can have that conversation with them. You can have that conversation with anybody. You know what's coming up this weekend. Why are we in jail? What are we doing? Here's Woody. But y'all did this intentionally. Mrs. Hilton, no, we did not. You and I had this conversation, Mr. Copeland, on Friday morning. Woody, you knew my child's birthday was next week. Mrs. Hilton, but what did I tell you when we met with each other? I said to you, you asked me, what is the one thing that's going to get me in jail? Didn't you ask me that? And what was my response? If you plead the fifth. And that is exactly what you did on the stand. Let's move it up. We're on 23. Then Woody, but what did I tell you before I got to that point? I told you the whole time, Tuesday, Wednesday, and Thursday. Uh-oh, it's gonna get serious, y'all. Mrs. Hilton, but I told you we were giving you immunity. Woody, that I was pleading the fifth. So he keeps telling me he don't want the immunity. He just wants to plead the fifth and go home. Mrs. Hilton, no, you did not. Woody, I told you every day I was pleading the fifth. So they even knew before he took the stand that he was pleading the fifth. And they don't supposed to let him take the stand if he's told them that. But they did it anyway. Let's keep going, y'all. We're on line 8. Woody, I told you my concerns. Now, Mrs. Hilton, and we said we would give you immunity. You said your concerns is what they know about you And when you said that, I said, well, you know stuff about them. And then I said, whatever your concerns are, we can give you immunity. Woody, so I didn't tell you I lied on them to get myself out of the situation? Mrs. Hilton, you said you were a liar. That's what you said. You said you were a liar. Woody's lawyer, was this recorded? Mrs. Hilton, no. Woody's lawyer, and did he ever say that Melnick was his attorney? Because she shouldn't have been talking to him. Exactly. Come on, let's get it. I like her, and she stay on him. 22. Mrs. Hilton, no, this week, when we first met you in the car on Friday, she got the man in the car. We asked you, is Mr. Melnick your attorney? You said he's not my attorney. I haven't ever talked to him. Woody, no, I never said he's not my attorney. I said I haven't talked to him. Uh-oh. So she should have stopped immediately. Oh my goodness. Okay, 3. Mrs. Hilton, you said he's not your attorney. You haven't talked to him. Then we continue to have a conversation. At no point did you ever say to us, hey, I want Mr. Melnick here. Hey, put Mr. Melnick on the phone. Here go Woody. You didn't make me feel like I needed him. Mrs. Hilton, but if you needed him, we would have said, if you would have needed Mr. Melnick, we would have said to you, okay, just call him. So, I mean, that is our position. We don't want you in jail. They are wrong, you guys. They don't supposed to do this. Okay, we just want you to be able to purge yourself by testifying. Whatever your truth is what your truth is, but you've just got to answer the questions. We believe that whatever your truth is what your truth is. We know what you said before. I don't know what you're going to say on the stand, but what we know is pleading the fifth is going to keep you in custody. That's what I know. Now, how you answer your question is how you answer your questions. I know what you said before, and I know what you said later. I mean, I know what you said before, and I don't know what you're going to say on the stand because you and I never went into full details about any of it. But let's move it up, don't want is you to be sitting here in custody. Woody, you did it. Ms. Hilton, I did not do it. You did it by pleading the fifth. Woody, you told me before you went to the judge with whatever the thing called you went to him with, you told me that I can't, when I'm asked the question, I can say I don't recall or I don't know. You told me that if I plead the fifth, I mean something. Why would I plead the fifth to something I ain't do? And I said that you don't know what I did and what I ain't do. And then you was like something, and then y'all asked for me for this immunity, and I was like, it was something. And then Thursday came, and then y'all gonna tell me, oh, we went to the judge with this, so you got to testify. If you don't testify, the judge gonna lock you up. Miss Hampton, right, but that was based upon what you, and then y'all that. Miss Hilton, no, you didn't. Uh-oh. It's getting deep. Okay, Woody, you said, why would I plead the fifth to something I didn't do? And I said, you don't know what happened. Go. Okay, 25. Miss Hilton, and I said, I don't know what happened. Only you know, and them know. I said, but you never said I'm pleading the fifth. You said, what if I do this? What if I do this? What if I do this? Woody, I told you, I said I'm going to plead you said, why would you plead the fifth to something that you know you didn't do? Woody's lawyer, so if you didn't have immunity prior to, is that what you are saying, that you feel like he didn't have immunity prior to? Woody, immunity came Friday, right when I went to jail. Woody is like, girl. Oh, this is funny. Okay, Hilton, the immunity only came after Mr. Melnick. Okay, let's move it up. We on line 14. Woody's lawyer, hold on. Miss Hilton, the immunity came after Mr. Melnick sent us an email saying my client is pleading the fifth. That was on Thursday evening at 6. Uh-oh, they getting caught up, y'all. They're getting caught up. They knew he was his lawyer. They called up. Okay, Miss Woody's lawyer. Okay, then Miss Hilton. So after that, that's when he where about? Okay, so after that, that was an ethic. He is pleading the fifth. Woody's lawyer. The Miss Hilton. We came and we got this signed. Woody's lawyer. She like, Miss Hilton. And then Friday morning came. Woody's lawyer. Okay. She like, y'all caught up. She knew that it was a lie. She knows. She being quiet though. Okay. So Miss Hilton. So between Friday evening, Mr. Melnick reached out to us, said he was representing him. He's pleading the fifth. Woody's lawyer. Okay. And when was the last time you talked to him before Melnick got involved? Miss Hilton, we talked to him earlier that day on Thursday. Woody's like, okay, and then how did speaks audible to Mr. Copeland? Woody, he called me. Woody's like, okay, I was just trying to get a timeline. She figuring these folks out. Exactly. Come on now. Okay, 13, line 13. Miss Hilton, sure. Right, so we have been talking since last Friday. So I met with Mr. Copeland last Friday, I think, out in the neighborhood. So then he came on Tuesday for court. We talked briefly on Tuesday, and then on Wednesday he came. Here go Woody. Thursday. He gonna call him out. Okay, Miss Hilton, no, I think he only came 2 days, so it had to be Wednesday and Thursday he came. It wasn't Tuesday, it was Wednesday and Thursday he came. And then on Thursday, once we left, is when Mr. Melnick reached out to us and said, my client is pleading the fifth. And at that point is when we went the next morning and got immunity motion. They scandalous, y'all. They are scandalous. And then we spoke on Friday morning. I handed Mr. Copeland this agreement and let him know that he has immunity and that anything he says we can't use. And then Mr. Melnick came and then we had court. Woody's lawyer. So you are pretty much saying you didn't ask for this? Woody, I didn't. Come on now. Tell on him, Woody. Tell on everybody else. Okay, Miss Hilton, but we gave it. He doesn't have to ask for it. Woody's lawyers. I know, he's just saying, Miss Hilton, right, he doesn't have to ask for it, but to alleviate whatever his concerns were, we gave him immunity. He didn't have to ask for it. Woody's lawyers. So if he wouldn't have had this, I'm just saying, this so he could understand it. I'm walking him through. Miss Hilton, Woody's lawyer, would he still had to testify, he have been able to plead the fifth. That's what he's saying. He didn't want it. Woody didn't want that. He just wanted to plead the fifth and go home. Miss Hilton, if he did not have immunity, Woody's lawyer, yes. Miss Hilton, yes, he could plead the fifth. Woody, that's what I am. Woody, Woody's lawyer, that's what he's trying to say. He's trying to say he didn't ask for this. Exactly. He didn't want that. Because y'all making this man testify. Okay, Miss Hilton, but he does have to ask for it. Now that we have given it to him, she said he doesn't have to ask for it. Now that we have given it to him, because that's on us. So now that we have given it to him, this is an order. He can still choose if this is the road he wants to take. Then he'll just stay in custody until the trial is over. And when we say the trial is over, every last defendant has been tried. Not just these 6, the other ones too. Woody, I done did longer time. Woody like, I don't care. Miss Hilton, all right, Mr. Copeland, I'm telling you that you're literally immune from prosecution from anything else you may say. That's that. She's still trying to push this thing on him. Okay, so the choice is always up to you, but we wanted to put on the record that state does not want you in custody. What the state would like you to do is purge yourself from, then here go Woody, What purge yourself means. Come on, Woody. Get on him. He ain't, Woody's, yeah, come on. Miss Hilton, meaning that you are no longer in custody, and the way that you purge yourself is to testify. That is kind of how it happens, and that is what the state wants you to do. We don't want you in custody. I can't say that any other different way, but we don't want you in custody. The only thing that's holding you is your refusing to testify. Okay, let's move it up. The judge is getting involved now. Okay. The judge, so do you have any questions and any other questions? Basically, if you invoke the fifth. Woody, I don't trust. I don't know what's going on. I don't trust nobody. I trust her word, but I don't know what's going on, Your Honor. Miss Hilton, this is your insurance. I don't know if you want to break that down to him. Woody Zori, well, he doesn't want that. The Lord, okay, here go the judge, y'all. Here go the judge. Let's pull it up so we can read it all the way down. We on line 9. Okay. But he's been given it. See, that's the challenge. Mr. Copeland, is that if they didn't give you the immunity, you could invoke your Fifth Amendment privilege. But what the state decided is they said your testimony is worth more to them at this point in time, and they really want to know what you have to say. So they have made from the state's perspective, they have made a decision to give you immunity so you no longer can invoke your Fifth Amendment privilege. You have to testify. So that's the difference in this particular scenario, is that they have taken away, well, you can still invoke your Fifth Amendment privilege. You still can do that, but the consequences of invoking it is you will just remain in custody. He should not be saying this to that man. So if you testify, you get out of custody and you stay out of custody until you're done. Okay, here go Woody. Let's move it up. Woody. And then if I don't testify, I have to stay in until when? Here go the judge. Until the trial is over. Until all the defendants have been, I've got these 6 that we have right now, and then there's another 6. Mrs. Hilton, no, there's another 12. The judge, there's another 12 or thereabouts that are still outstanding in various forms or another. Woody, can I speak with her for a second? The judge, yes, sure. Judge Glanville, Assistant Director Attorney Simmons Hilton, and Court Reporter Christina Weaver, and the investigator Antonio Long and Rashid Hamilton left chambers at 10:17 and returned at 10:33, so they was gone like 15 minutes. Then Woody comes back in. My question is, I can ask you a question. The judge, yes. Woody, so my question is, so what I was just asking her was, if you ask me a question and you feel as in I was lying about it, you will lock me back up? Then Ms. Hilton, no. If you, so you are saying, you say I didn't talk to Demican. Well, no, I can't talk about that because the judge is in here. Okay. You're asking, for example, if you said before that the sky was blue and I asked you on the stand what color, let's move it up, is the sky, and you say, I said it was red, I'm going to say no, back before you said it was blue. Is that what you're trying to ask me? Woody's lawyer, so explain the independent evidence. If he's saying, if he says he did something and you know he's not telling the truth, what happens? Ms. Hilton, if he said he did something and he did not do that thing, Woody's lawyer, if you believe he did not, so if you believe that he's lying about that, Ms. Hilton, then no. If he missed to doing something on the stand, Woody's lawyer, Ms. Hilton, and he did not do that thing, Woody's lawyer, Ms. Hilton, I'm going to say, is this the first time you are saying that? Woody's lawyer, and you have independent evidence to prove it wasn't him, then what? Then nothing. What do you mean? Like, it's getting good. She confronted on what I said. Okay. Woody's lawyer, so then he will be fine? Miss Hilton, yes, but Woody's lawyer. So you're okay with him if he got on the stand and said things that weren't true? Y'all listen to this. Miss Hilton, no, I want him to tell the truth. What? Okay, let's move it. Have I always said to you, I want you to tell the truth. I don't want what's going to come out your mouth. I expect you to tell the truth. If you say something that is inconsistent with that you said before, then I'm going to ask about the inconsistencies. But I expect you to tell the truth. What you go on the stand and do, I don't know. I don't know what you are going to do. I want you to tell the truth. But I will deal with you not. And then she breathes. You're saying something different in the manner that I normally do. Here go Woody. If I'm saying something different, right? So when the police question me, they done question me every time they lock me up. I don't know how many times that was. I done told them whatever different story I could think of to try to get out of the situation. I don't recall what I done told them. Miss Hilton, okay, so you can say I don't recall. That is how that works. I don't recall. Woody's lawyer, and he can say that to everything, to every single question. Miss Hilton, I would hope that it's not the truth, because I think there are some things you do recall and some things you don't recall, and then I will go through my process of what I do. Okay, let's move it up. You can talk to him about what impeachment is. That won't get you locked up. Impeachment will not get you locked up. You can talk to him about what impeachment is. If he says, I don't recall. Here go Woody. What will get me locked up? You want to know what will get me locked up? Miss Hilton, what did I tell you? Woody, I don't know. Miss Hilton, what you did on Friday, I plead the fifth. If the court instructs you. Here go Woody. So the only thing that gets me locked up is pleading the fifth. Woody's lawyer, yes. Ms. Hilton, the court instructs you, you need to answer the questions. You say again, I plead the fifth again. That's what's going to get you locked up. But if you answer the questions, that will not get you locked up. Then Woody says, so if you don't want me in jail, why you just don't let me go after the trial, or why you won't let me go after the trial's over with? Hilton, you are in jail because you are not answering the questions. Okay, here goes the judge. Okay, line 22, the judge, because you have been given immunity. Ms. Hilton, because you have been given immunity, you are only in jail because you got up there. And here's Woody. Well, what about this? I answer the questions, you take away immunity. I answer the questions and I plead the fifth. Miss Hilton, no. Here go Woody. 2 questions that I feel incriminates me. Miss Hilton, but then here go Woody. I won't plead the fifth to things that don't incriminate me. The judge, the state can still give you immunity. They can give immunity to whoever they want, okay? And they can make that choice. I don't even make that choice. So if they, like I said earlier, they want your testimony. They figure it's that the jury needs to hear what you have to say, good, bad, or indifferent. And what Miss Hilton is telling you is just tell the truth as you know it and let her worry about. I mean, even though you may have said different versions of whatever, that's for impeachment. That's not going to get you in trouble. Okay, let's keep going what this judge is saying to this man. What will get you in trouble is you just invoking your Fifth Amendment privilege because you have been given immunity. Or as Ms. Love said this morning, remember, Ms. Love said if you overtly lie about something, like if you tell a bold-faced whopper, then they can indict you on that particular charge. I mean, that particular false statement. Okay. Come on, Woody. Don't let them work you, baby. Okay, Woody. That's what they're going to do. Exactly. Woody's lawyer. That is what I was saying. You will be right back here. Miss Hilton, but if you say something that you know you did not do, like you admit to something you know you did not do, whether you, here go Woody, like murder, don't have, like no statute of limitations, right? Exactly, Woody. Miss Hilton, but if you didn't do it, I can't charge you with something you didn't do because I don't have any other evidence but you saying it. But you could go get evidence. I just said that, y'all. Come on, Woody. But y'all don't. Like, and Woody's sorry. You can charge him with false statements and he will be back in jail. That is what I'm trying to say. Get him, y'all. Get him. Okay, let's move it up. Miss Hilton, but if I know that you are lying about that, I do not intend to do that. If I know right now he's lying, I know he's lying. I'm not going to charge you because I don't know your reason for doing that. But they saying telling him to lie. But I'm not going to charge you when I know you didn't do what you are trying to say you did now. Y'all, this is scandalous. And that can be a part of this. I know you didn't do it. Woody, but it's up to the judge to do that. Ms. Hilton, no, it's up to the state to bring charges. The judge, I don't have anything to do with that. Ms. Hilton, he has nothing to do with bringing charges. That's up to the state of Georgia. Woody, can I talk to my family and I will make my decision right after I hang up the phone? Woody Zori, he said he hasn't been able to speak to anybody. Ms. Hilton, his sister just called us. She had to think about it. Yeah, what you talking to that boy's sister for? Woody, y'all done me wrong. Y'all just hold me in the jail. Don't let me get no PIN number, no nothing. Ms. Hilton, we have no knowledge. We did not know that you, Ms. Woody's lawyer, he hasn't been able to do anything, speak to anyone. Here's Woody, the jail system's down, but y'all still putting people in it. Okay, Ms. Hilton, that part I don't know. I know we have been in communications with your sister. Your sister actually texted Mrs. Lansquat to make sure you were okay. We told her we physically had laid eyes up to the sheriff's. I don't know. Then a brief pause. Woody, so what you think what she's saying? Ms. Hilton, I can tell you right now, Woody, I'm talking about that locking me back up. What you think about y'all locking me up? Okay. Ms. Hilton, we would have to bring charges. There would be no incentive. Woody, y'all will. Ms. Hilton, we've already had this discussion. Woody, look, what you did to me. You waited until Friday and did this. I done told you every day before Friday came that I was pleading the fifth. They knew it. And they let that boy get on the stand. Oh my goodness. Miss Hilton, no, you did not. Look, she trying to, as a matter of fact, our last, here go the judge. Let me move it up so we can read the entire thing without stopping. Mr. Copeland, let's see if we can get beyond this. Okay, beyond what your concern is. You could have invoked the Fifth Amendment privilege. The state could have turned around and said, stop, had me, and then he pauses. Go ahead and file that motion and giving you immunity. It was going to that decision. They decided to make it on Friday. So even if you would have been more comfortable testifying and invoking your Fifth Amendment privilege, they could decide you as a witness that wants your testimony more than they do you invoking your Fifth Amendment privilege. They gave you immunity. So you've... Come on, the judges. Oh, he got a long one for him. You got to testify truthfully as to what your knowledge of the particular incident is. I mean, so they could have done that anyway. Even if they put you on the stand, they could have said stop and gone ahead and given you immunity. They could have done that. Then here goes Woody. So can I get it that if I was to testify, that if she feels as in I lied about anything, that they won't lock me back up? The judge, let me have that, Mrs. Bumpus. Mrs. Bumpus hands documents to court. Brief pause. Let me move this up, y'all. The judge is speaking again. Okay, here's the judge. Mr. Copeland, on page 2 of the order. Here's the order, you guys. OCGA 24-5-507. However, no testimony given by Kenneth Copeland as required under this order, or any information directly or indirectly derived from the testimony of Kenneth Copeland given by Kenneth Copeland as required under this order shall be used against said Kenneth Copeland in any proceeding or prosecution for a crime or offense concerning which he testifies under his order. Okay, so you testify about some aggravated assault or murder, they can't prosecute you on it because that is what it says on the order. That is not true, Judge, and you know it. Okay, the only thing that will get you in trouble is this next little paragraph. Kenneth Copeland shall be subject to prosecution or to penalty or forfeit for any perjury, false swearing, or contempt committed in testifying or failing to testify in accordance with this order. However, it is ordered that Kenneth Copeland shall not be required to produce evidence that can be used in any other court in this state, the United States, or any other state. So basically, if you commit perjury, false swearing, or contempt committed in testifying, that means if you just invoke your Fifth Amendment privilege or failing to testify, you say, I'm not going to testify. All right, so the only two real things you can kind of get in trouble for are perjury and false swearing, as long as you tell the truth. Now, as Mrs. Hilton and Mrs. Bumpus said earlier, you may have told or been asked about situations over and over again. They may have changed. What the state is asking you to do is tell the version that really is the truth. If they want to impeach you, they can do that. Let's move it up. Or if the other side wants to impeach you, they can do that. You won't get in trouble for that. Woody, you said, I will. The judge, you will not. You will not. Impeachment is not perjury or false swearing. Okay? Woody, but she said I can purge myself though. Come on, Woody. Woody's smart. He's very smart. Miss Hilton, no. We're saying two different things. Sorry. Perjury is if you get on the stand and you just say a bold-faced lie. Just something that is just wrong. You say I did something, and all the other times you have said I have not done it, and really, while it's perjury, it's really just an inconsistent statement. Like if you get on the stand and say I did X, but in 2015 you said I never did X. That is what I'm going to impeach. I'm going to impeach you on everything you said in 2015, meaning I'm going to say, okay, today you said I did X, but in 2015. Lieutenant Dean enters chamber. Lieutenant Dean, we have a security issue. We need to stop for a minute. If we can stop for a second, please. Judge Glanville and Lieutenant Dean exit chambers at 10:45 a.m. Judge Glanville returned to chambers at 10:47, 2 minutes later. Miss Hilton, I don't know what was told to you on Friday. I have no reason to want you in prison. You have spent enough time in prison for YSL, period. So why would I want that for you? That doesn't make no sense, I said. And she said, let me see what she said. I said it to you before, and I will say it to you again in front of all these people. It makes no sense. Woody, you just said I'm going to have to stay in jail until the last. Then, Miss Hilton, if you don't testify, get this part through your head. If you don't testify, that is the only thing that is holding you, that is literally holding you. Literally the only thing holding you right now in the fact you keep saying, I'm not going to testify. Well, you haven't said it today. I'm not testifying. I plead the fifth. If you get up there and I want you to tell the truth. Like I said before, if you don't recall certain things, you can say you don't recall. That's fine. I want you to tell the truth. I don't expect you to remember every single detail from 2015. I just don't. No one here does. But what I do expect from you to do is answer questions so we can get through this. So you can go home, but with your baby for her birthday. And see these dogs deliver their babies. Go talk to your nephews and do all these other things. Let's move it up. Woody, how you know about my dogs? Mrs. Hilton, because you told me. Woody, okay. Woody's lawyer, what's wrong? Then let's look. Woody, I'm stressing at another level, like, and Woody's lawyer, I mean, can he, I'm saying, then here's Woody, I'm weak. I'm dead serious, man, like, and Ms. Hilton, this is what our position is. We do not want him in custody. We want him to tell the truth. We want him to testify. That's what will get him out of jail. And you know, you have to make, and Woody's lawyer, if he decides in 2 weeks he wants to testify, then what? Ms. Hilton, if he wants to stay in jail for 2 weeks, then that's, I don't know why you would want to stay in jail for 2 weeks. I have no idea. Woody's lawyer, he just feels like he's under a lot of pressure right this second. Then Woody, even at the jail, they are just, you can't give me house arrest. No, you can go home by taking the stand and testifying. That's what you, here's the judge, and come back tomorrow. And Ms. Hilton, we keep on saying yet, but there is no crime. We keep on saying yet. I don't know who is telling you about a crime. There's no crime. You have done nothing wrong except for not. Then Woody, so why am I in jail then? Ms. Hilton, because you aren't testifying. Woody, but that ain't nothing wrong. It's not a crime. Ms. Hilton, it's not a crime, but you're in civil contempt. Things. Because you invoked your privilege after you have been given immunity, that is why you're in custody. Because you get out by testifying. So you testify, you get out. That's why I was going to bring you. Why I brought you here early today to just inquire about that. You can remain and hold your position of invoking the fifth or not testify, but you go back to prison. You go back to jail because that's, and then Woody, you can't sentence me? And Woody's sorry, there's no sentence. The judge, there's no sentence. The contempt is compliance. That's what they want you to, your testimony. That is all they want, whatever that may be. Woody, I don't know what it is, Your Honor. Ms. Hilton, so listen, you are in jail for failing to testify. The judge, failing to testify. Ms. Hilton, not for nothing else. There is no crime. You ain't done nothing. I don't know if people are telling you that we are going to charge you with nothing. We are not charging you. The state charges you. There's nothing we're charging you with. You are only in custody because you have decided not to testify. That is it. Once you decide to testify. The judge, remember that word you were talking about, purge? Woody, The judge, okay, you can purge right now. Purge, get yourself out of jail just by testifying. Okay. Woody, I can purge and get out of jail? The judge, yes, just by testifying. Ms. Hilton, not perjury. The judge, purge, meaning you can get out of jail. You can get out of jail, out of custody just by testifying. Woody, and what about the other one? The other word, perjury. Get him, Woody. Come on now. The judge, Ms. Hilton, that's different. The judge, that's a different word, okay? Woody, that can get me back in jail. Ms. Hilton, yes. The judge, perjury is, then Ms. Hilton, she cuts the judge off. It's not. What is perjury? What you are saying is what we call a prior. A prior inconsistent statement. Your example that you gave me, what if I said I did something and I know you didn't do it, and you said before you didn't do it, that's not perjury. That is prior inconsistent statement. Brief pause. Woody's lawyer, you've got to make a decision. So if he starts testifying today, he's going to go home. Ms. Hilton, he should so long as he remains. But if you get up there and be like, if you get to testifying and then we get into it and you start saying, I plead the fifth, we're going to be back here again. Willie's lawyer. But if he says he don't recall to everything, he'll be okay. Ms. Hilton, I'm not advising that. But so long as he answers the questions, that's fine. So long as, Woody, I did these crimes. I'm telling you that. Oh, Woody's admitting to him. Miss Hilton. Okay, I don't know what you are talking about. She's ignoring what he just said. Woody Zoya, I think, are you saying you want to get up there on the stand and say something? Woody, no response. Woody Zoya, did we find out if he could talk to his family? No. Brief pause. Miss Hilton, I mean, if it's okay, we got the sister's number. And then Woody, as my attorney, you gotta... Miss Hilton, if y'all want to talk, let me go somewhere where I can hear you. Can't hear you. The judge is over there, so just speak low so he doesn't hear you. The judge, hold on. Judge Glanville handed the document to Attorney Kayla Bumpus and exited chamber. Assistant District Attorney Simone Hilton, Investigator Long, Investigator Hamilton, and Court Reporter Christina Weaver from 10:53 to 11:28. Okay, so that was about 30 minutes. Okay. The judge. Okay, all right. Mr. Copeland, have you had an opportunity to talk with Mrs. Bumpus, your lawyer, and Mrs. Hilton, the state counsel? Have you got any other questions? Woody, no, Your Honor. The judge, is it your desire to give testimony? Woody, yes, sir. The judge, okay, all right then. Do you all have some clothes for him? Miss Hilton, I don't know. Let me go take a look. What size are you? Woody, I can't hear you. Miss Hilton, what size are you? Woody, little. Investigator Hamilton, we had a large jacket for him on Friday, large. Miss Hilton, you had a jacket for him? Investigator Hamilton, yes. Miss Hilton, oh, but he can't wear a large. The judge, what is your waist size? 34? Woody, 32. Judge, chest, what are you? 34, 36 chest? Miss Hampton, probably 36. Woody, not in my chest. What do you mean? The judge, size. Miss Hilton, what size are you? Small or medium? Woody, small or medium? The judge, they're going to try to get you some clothes so you don't have to testify wearing that jail uniform, okay? Woody, y'all don't want to show the people how y'all did me. Right, Woody, okay? The judge, look, if we can't find clothes, then you may have till tomorrow. Woody, I prefer to go in like this. Well, he want to show them what they did to him. Miss Hilton, I understand what your preference is. Woody, nah, don't hide it. Woody Zoya, can you make him put on the clothes? Miss Hilton, no. Woody, I want to go in there like this. Miss Hilton, fine with me. The judge, all right, okay. Woody, you ain't going to try and lock me back up for this. Because he didn't want to change his clothes, that's what he said. He said, so long as you testify, we will get an order to get you released. Woody's lawyer, today, the judge, whose copy is this? Miss Hilton, you've got to make sure you come back now. I want to be real clear. Woody, when have I ever ran? Miss Hilton, you have not. That's the only thing you have not. The judge, whose copy is this? Hilton, that was ours. Do you want a copy? You can take it though. Woody's lawyer, okay. Miss Hilton, do you still have your, or you threw it away? Let's move it up. Woody's lawyer, I'm going to give him both of these things so he can have some information. Miss Hilton, okay. The court reporter, are we off the record now? The judge, are we done? Woody's lawyer, yes, I believe so. The judge, okay, we're good. See everybody downstairs in about 10 minutes. The proceeding concluded at 11:31 a.m.